Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome back to our latest private clients podcast, Trust Matters. In this podcast, we are exploring a number of the trust issues that we see on a regular basis at Hall & Wilcox, and these trust issues relate to trusts in Australia. Last week, we had a discussion about trust variations and some of the complexities that we see with trust deeds. What we're shifting onto today is to talk about trust disputes and exercise of trustee discretion. Now, this has been quite an interesting area. It was quite a dead area, if I can use that. And then over the last 5 or 6 years, quite a few things have happened. I've lost quite a bit of hair during that time. I've had a son, but more importantly for today's discussion, we've had quite a few cases, especially in Victoria and in Western Australia, about the exercise of trustee discretion. So what we'll do today, myself and my colleague David Dickens, who's a partner in our dispute resolution team and regularly advises clients and is regularly in court as well on these matters, are going to talk through some of those practical considerations when it comes to exercise of trustee discretion and what we need to be considering and what we need to be concerned about as well. When we consider this more broadly, one of the biggest factors here is that a lot of people have had discretionary trusts or family trusts in particular that have been running businesses, they've been building up wealth, and there might be a transition that's coming up in the next 10, 15, 20 years, looking to pass control to the next generation. And often people have been running these trusts as though they're their own assets and making decisions on that basis. With these recent cases, what the courts have really looked at is proper processes, making sure that the trustees are acting properly, exercising their duties, and that's what we'll really talk about in more detail today. So, David, first question for you. What are you seeing in the landscape with trust disputes in a general sense?
Thanks, Will, and hello to everyone listening in. Certainly the themes in trust disputes, there are more that we're seeing as well, and I think also on a sometimes related note, probably more shareholder disputes as well. But we're seeing it in a few ways, and the first is there can be trusts that are coming in a lot of sense to the end of what's probably their useful life. So it may be that the parents or probably more the grandparents, or even further back a step, established a large trust with substantive assets. And as time goes on, obviously the family pool gets broader and you get more and more people with varying needs, and you have control of the trust is generally confined to one or a few people, but you have this wider and wider class of beneficiaries, and that can simply lead to disputes because you just have these people with very different needs and expectations. And so what we are seeing is disputes arising out of trusts that had been running quite effectively for, in some cases, many decades, but they're now coming towards that point where should probably look at bringing it out to the next generation or separating it, or you've got assets in there that need to be sold. And I can think of a few examples there where there's a decision made to sell the property, the business, whatever it is, and that can kind of crystallize this question of, well, what do we do with it? And
because sometimes if you keep those trusts going, you're setting yourself up for bigger issues, aren't you? Because as you say, there's so many more people to consider. There's so much more influence on those beneficiaries, maybe by in-laws or by other parties, about getting assets out or closing trusts down.
Absolutely, and I think it's important for people running trusts to think about and take a step back and ideally try and do this before a dispute arises. So, if you've got a family trust and it's you and your sister and your brother and your parents, that's often that's quite workable. But give another generation or two, and suddenly you've got perhaps a significant source of income for many people that's now tied up amongst cousins that you hardly see, second cousins, the wider and wider family living overseas. It can become just sort of fraught with difficulty, and you may get to the point you think, what is the benefit really in having this big family group all tied together in this? Why not distribute some of it out and push it down a bit so that someone's one person's personal issues don't become another person's personal issues, and just get that separation.
And that's often where we then start to see those issues coming up, that if people are looking at selling assets of the trust and looking at distributing income or capital out of the trust, or potentially closing a trust down, that's one of the more common exercises of trustee discretion that we see, David. And that's where we're often really now starting to see a lot of these litigation concerns coming up, that the trustee has to make a decision. Are they actually doing that properly? Are they considering the right things? Perhaps you can talk us through that aspect of, if you are a trustee, what should you be doing and what maybe shouldn't you be doing at the same time?
Absolutely. So the starting point as lawyers advising, whether advising a trustee or a beneficiary, the starting point is always, what does the deed say, and any variations? And what we've noticed is people, trustees or the directors open up the trust deed and you read it, and it seems sort of almost like a royal type power, in that it says the trustee can essentially do anything. It grants this huge list of powers, including, as Will said, the most critical power being to the discretion to distribute any or all of the income or capital to whatever beneficiaries the trustee sees fit.
We might just pause there just briefly, and just to expand on that class of beneficiaries, as you've said, David, can be very, very broad. So in some instances, it might just be a direct family line, but then you've got other instances where that can be cousins, uncles, aunts, nieces, nephews, in-laws, so on and so forth. And often people, I think, don't necessarily realise that it is a full discretion, and there are a very broad class of beneficiaries who need to be considered or should be considered.
Absolutely. And you have this very broad power under the trust deed, but what trustees may not appreciate is, even though it's not written in the trust deed, the law actually imposes quite high obligations on the trustee. It's what the law calls a fiduciary obligation. That means that even though the trustee has all of these very broad powers, it still needs to exercise those honestly, in good faith, and on a real and genuine consideration, and without an ulterior purpose. So there are actually essentially barriers or limits on what the trustee's powers are practically, but often that's not realised by trustees. And what we are seeing is there's been some recent case law in this area, as Will said, where decisions of trustees have been successfully challenged by beneficiaries. And what that is leading to, I think, is more beneficiaries thinking, well, actually, I might be able to challenge what's happened here. I'm not happy with how the trust has been managed, and so that's resulting in more disputes. And one of those cases, which is quite well known, is the OEs and JJE nominees decision of the Victorian Court of Appeal. And what we're seeing is disgruntled beneficiaries who are trying to sort of establish cases, and they're very much looking at the recent case law on this and trying to sort of fit their facts within those parameters to see if they can successfully challenge a trustee's decision. And so there's that, and then what you see on the flip side, of course, is trustees saying, well, I would like to avoid that sort of being in that position. So we get the question of, well, how do I minimise litigation risk, which is really a question for a trustee of, well, how do I make sure I comply with all of my obligations?
And it's a very real risk for the trustees, isn't it, David? Because if a beneficiary is successful in an application about the trustee's discretion, there's a very real risk that trust that has built up the family's wealth, that maybe operates a business, that maybe is key to the success and the financial viability of the family, that they lose control of that. That's really the big issue, isn't it?
Yeah, absolutely. And it's one of the challenges of trust disputes is that from a disgruntled beneficiary's perspective is the relief they can seek from the court may be something that is actually not going to help them that much, but it's kind of all they can ask for. So a common relief you'll see sought by a disgruntled beneficiary might be along the lines of they want to set aside distribution made by the trustee. So say, set aside the distribution of all the income and capital of the trust that was made to John. And they might also seek that a new trustee is an independent trustee is appointed because it was John controlling the trust. Now, the interesting challenge for the beneficiary, of course, is that's not really what they want. What they probably want is $100 being distributed to themselves or being split between themselves and John or apportioned in some way. But generally, that's not something you can really ask the court for. So, and the other thing you can end up with is this difficult position of if they're successful and that distribution is set aside, that means there was no distribution made of that income in the financial year, and there's potentially tax consequences or takers in default, and having someone else appointed as a trustee may or may not actually get the beneficiary a better outcome. Another trustee might make the same decision or might make a decision that's even worse. So for a beneficiary, it could still be quite hard to actually get their case to where they want to get to. And really, that's one of the reasons why people try to resolve these matters at a mediation if they can.
And that's often where we get to with these discussions, isn't it? It's a private mediation, or it's a mediation as part of a court process to try and reach an outcome between the parties.
Absolutely. And statistically, we know that a lot of, certainly most litigation does settle, but that can take time, and some matters don't. And that's, we have these reported decisions, particularly a few more of them in recent years, where people run these cases because there can be a lot at stake, and if people won't compromise, then you end up having the court impose an outcome which may be an outcome that's not really in anyone's best interests, practically speaking.
So we've talked about some of those duties, and we've talked about some of the circumstances that often come up in these types of disputes and discussions. If we come back to the trustee itself, David, and focusing specifically on what a trustee can do to try and reduce those risks, perhaps you can just step us through some of those examples. And I appreciate this is very much a general conversation. There are specific requirements for specific deeds, and a lot of deeds are different. So maybe just at a general level, you can talk us through some of what a trustee should be doing when they're considering the exercise of a discretion.
Is a very good question, Will. So that the first thing the trustee must do is actually read the trust deed and understand what's in there. As you say, that is the guiding document, and it's, you can't give sort of general advice. You always need to look at the specifics in there, particularly understanding who the beneficiaries are, because that can take a bit to tease it out. And as you remarked earlier, Will, it can be a very broad class of beneficiaries, and that may not be appreciated, particularly where you've got modern blended families. There can be a lot to work through and understand who actually is a beneficiary or potential beneficiary there. Something that a trustee generally needs to do if it's considering exercising the power to distribute income is inform itself as to the specific needs and qualifications of the beneficiaries. What that means practically is really the trustee should know obviously who the beneficiaries are and what their needs are. If there's a beneficiary with medical needs that they need funds for, if there's a beneficiary that needs funds for educational needs. On the other hand, if there's a beneficiary that's very well off and doesn't have any apparent financial needs, those are matters that the trustee should really inform itself about. Now, that of course is the lawyer's answer, and if you're acting for the trustee, what you hopefully see is some wonderful questions that were asked of beneficiaries by the trustee. Of course, in reality, it's not really how family trusts generally work. A trustee is allowed to inform itself. It can just take into account what it already knows about a beneficiary. So if you know your sister's financial position because you have dinner every 2 weeks and you talk about that sort of stuff, you don't need to send a letter asking her that. You already know it. But where this gets tricky, I think, is where you have beneficiaries that may not know about the trust or may not know what's in the trust or may not know that the trustee is considering making a large distribution. And the trustee is then faced with the position that ideally it would be writing to these beneficiaries and asking questions, but If you do so, it can also lead to questions from beneficiaries and can also create expectations from beneficiaries. The second cousin may suddenly expect to receive a wonderful windfall, whereas it's not really the intention to be making that sort of distribution to that person. So that is one area I think that needs very careful consideration by trustees, is this how it informs itself as to the needs of the beneficiaries.
And probably how broad you go as well, David, to the point about some of the trust deeds that are very, very broad in their classes of beneficiaries. I think sometimes you almost need to pull that back and really look at the purpose of the trust and who it was set up to primarily benefit, and focus first and foremost, it's probably fair to say, first and foremost on those primary classes of beneficiaries.
That's right. Certainly they're the ones that have just to speak loosely, the stronger entitlement or probably need there. And things like looking at what distributions have been made in the past, as you say, what was the purpose of setting up the trust? Those are all things that the trustee should inform itself of. And the other, when we're talking about trustees making distributions and exercising its power, the other very interesting point is reasons for the decision. So the trustee usually will say something that just gives this discretion to the trustee to make a distribution, and there's not really, you see in trustees, there's no obligation imposed on a trustee to explain or give reasons as to why it is that it's decided to give $100 to Bill but not to Nancy or whatever it is. And there's some interesting...
Because it's ultimately discretionary, so there's no compulsion to go either way. It's ultimately we consider and then we make a decision, isn't it?
Absolutely, yeah. It's just this power to make the distribution. And there's some case law that's come up around this, and helpfully the courts sort of recognise the unique position of family discretionary trusts, and the case law tells us that a trustee has some protection from needing to disclose reasons and motivations, because that can be, to quote some of the cases, abrasive or distressing or likely to embitter family feelings and the relationship between them. So that's kind of common sense, isn't it? If you had to write to all the beneficiaries and explain, well, this is why I've decided to give money to Jill and not Jane, that's probably going to get people riled up, because once you start giving reasons, people understandably, but they will almost inevitably have a different perspective on it. So at law, there is no obligation on a trustee to give reasons for its decisions. Now, of course, a trustee can make a decision there. It can still give reasons if it chooses to. But if a trustee doesn't give reasons, then it won't be compelled to give reasons. But if it does give reasons, then those reasons themselves can be examined for validity as to its manner and method. So if a trustee chooses to give reasons, those reasons can be examined by the court and prodded and poked, and the court can look at those reasons and sort of the substance of them. Whereas if you don't give reasons, the court cannot undertake that sort of exercise. So a lot of trustees will decide not to give reasons, and when you look at the minute of the meeting where the trustee makes this decision, it will be quite anodyne. It will just recite the trust deed and just say, X dollars is distributed to beneficiary X and so forth, and not give any reasons. And that gives the trustee that protection from having its reasons examined. So that's something that often needs close consideration, because sometimes there's some desire, very understandable, to explain the reason or give some justification. But you just need to be a bit careful. Once you start doing that, then you've kind of opened up the box, and then the substance of the reasons can be examined.
Genie's out of the bottle.
That's it, and you can't put it back in.
Good. Well, that's a really good overview of those considerations. Was there anything else, just maybe in closing, Dave, that you wanted to just bring to our audience's attention in relation to trustee discretion?
Look, the only other comment I'd make, I'd say this a bit, the trustee beneficiary relationship, it's very asymmetric. So the trustee has these high duties imposed by law. A beneficiary has no obligations. They're not even a party to the trustee. They haven't promised to do anything. So a trustee is held to a high standard, and that that can be quite frustrating, to trustee clients of ours, where you have a beneficiary making sort of quite unhelpful decisions, or approaching the family dynamic in a particular way. But the more people are doing that, the more important it is as a trustee to remain polite and respectful in all dealings with the beneficiary, because there is that much higher expectation on the trustee. So it's just, I raise that as just another example of the very unique nature of family trusts and the laws around it.
And that's probably a good practical point to close on, in the sense that if you are concerned about someone in the family that might be agitating issues, it probably almost lifts the trustee to a higher level of consideration, because they really need to make sure that they are doing what you've said, David, so that they are considering those duties, they are getting the information they need before they exercise that discretion, and they are doing the things that they should be doing as a trustee, as opposed to simply treating those trust assets as their own assets and doing what they want to with it, really just to try and reduce the risks that would otherwise be there if they didn't follow that proper process.
Very well summed up. I agree, Will.
Great. Well, we might close our episode today on that note, and I might just say as well, we started to talk a little bit there at the end about beneficiaries' rights. We will actually be talking in more detail about beneficiaries' rights and access to information in our next podcast series with another of our colleagues, McLean Edinger, who heads up our estate disputes team and is based in our Perth office. Thank you everyone for listening, and we will speak again soon.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.